Hey, what's up? Jonathan Masters. Entering into public record this settlement agreement. So everybody's pissed off at Jill Stein for running, as a candidate in an American election. Most Americans are opposed to freedom, so they hate the independents and the third parties, laugh at them, disrespect them, but they don't realize the major obstacles that third parties have to go through. So Jill Stein is going to get more money for her re-election campaign, for her Recount campaign, Recount in Pennsylvania, Wisconsin, and Michigan. She got over $7 million donated to her, which was more than both her 2012 and 2016 campaign combined. $3.5 million for the second one, $1 million. So she only had $4.5 million, combined for the two presidential elections. But for the recount of Pennsylvania, Wisconsin, and Michigan, she was able to get over $7 million donated to her. So did she win? Did she do anything? God, what did all that effort go towards? Are we going to get anything out of this? And the answer is yes. We got a Pennsylvania settlement. So people say, well, what good did it do? The Pennsylvania settlement. So the state of Pennsylvania is going to have better election systems and democracy. They're going to have paper ballots, and they're going to be auditing their system periodically. So they're going to have election integrity. So for the longest time, Pennsylvania didn't guarantee election integrity. But because Jill Stein had pushed for a recount, and they're going to deny her of, the government's not going to listen to it, but then she's going to sue them for money for not listening to. So the governor was already promising to essentially update the voting system, so they just said, hey, why don't we make this agreement? Well, the promise that Governor Wolf, the promises of Governor Wolf is that, the ones that were on the table is now going to be part of this legal settlement. And so Jill Stein's got a victory, a major victory, the Pennsylvania settlement. The Pennsylvania settlement, it was a historic effort anyways. So the fact that Ajumu Baraka and Chris Hedges is going to be opposed to Jill Stein, and yet Tucker Carlson is going to defend Jill Stein, that should tell you something, right? Anyways, so basically, liberals, in order for liberals to succeed, you're going to have to succeed by yourself. The moment Jill Stein gets power is the moment the rest of the liberals blunder it and fall over themselves. So this is what Ajumu Baraka and Chris Hedges was against. They're going to have a better democracy in Pennsylvania. And, they tried to stop Jill Stein in the very beginning. They were, put out their opinions, so they wanted, to use their influence. Anyways, I'm just going to put this into the public record. There's 12 pages here. So I'm going to read, not verbatim, but pretty much verbatim, the settlement, okay? So this is November 28, 2018, so just last year. The title, Emery, Selly, Brinkerhoff, and O'Brady, LLP. Emery, Selly, Brinkerhoff, and O'Brady. That does not roll off the tongue, so that's a law firm. Okay, so the Honorable Paul S. Diamond, United States District Judge, Eastern District of Pennsylvania, Philadelphia, Pennsylvania, 19106, regarding Stein v. Cortez, number 216-CV6287-PD. Your Honor, we represent plaintiffs in this matter. We are pleased to report that the parties have settled this case. See settlement agreement attached as Exhibit A. Pursuant to paragraph 13 of the settlement agreement, the parties will shortly submit a proposed stipulation in order dismissing the case, but retaining jurisdiction to enforce the terms of the settlement agreement. Respectfully, Ilan Mazel. Ilan M. Mazel. Exhibit A. And it's just a blank page. So you have, this case, United States District Court for the Eastern District of Pennsylvania. Jill Stein is the plaintiff, along with Randall Reitz, Robin Howell, Shannon Knight, Emily Cook, and Kimberly Kupka. versus Pedro A. Cortez in his official capacity as the Secretary of Pennsylvania, the Secretary of State, Secretary of the Commonwealth, and Jonathan Marks in his official capacity as Commissioner of the Bureau of Commissions, Elections, and Legislation. So apparently you're not allowed to sue the state, but you could sue the individuals who run the state. So you could sue the Secretary of State, and you could sue, Jonathan Marks and Pedro Cortez. Jonathan Marks is Commissioner of the Bureau of Commissions, which is redundant. And then he's the Commissioner of the Bureau of Commissions, Elections, and Legislation. So that's an interesting department. They run elections and commissions and legislation. They kind of run the whole thing, but like over here and over there. So Pedro A. Cortez, Jonathan Marks is who Jill Stein sued. And then here's the settlement agreement and release. Number 1, introduction. This private settlement agreement and release. The agreement is entered into as of the date of the last signatory effective date among the plaintiffs, Jill Stein, Randall Reitz, Robin House, Shannon Knight, and Emily Cook, and defendants Robert Torres in his official capacity as acting Secretary of the Commonwealth, and Jonathan Marks in his official capacity as the Commissioner of the Bureau of Commissions, Election, and Legislation. Voter verifiable paper ballots for every voter. The Secretary will only certify new voting systems for use in Pennsylvania if they meet these criteria. A, the ballot on which each vote is recorded is paper. They produce a voter verifiable record of each vote. C, they're capable of supporting a robust pre-certification auditing process. Number 3, the Secretary will continue to direct each county in Pennsylvania to implement these voting systems by the 2020 primaries so that every Pennsylvania voter in 2020 uses a voter verifiable paper ballot. 4, to ensure that new voting systems meet the criteria set forth in paragraphs 2 to 3. And to work collaboratively to further the party's shared goal of promoting reliable and secure voting in Pennsylvania. Designee plaintiffs will be invited to observe the certification process to that end. A, the Secretary shall ensure that the plaintiffs are made aware of all currently scheduled and future scheduled Commonwealth on-site certification testing for voting systems. B, plaintiffs will appoint a person to attend any and/or all on-site certification testing undertaken by or on behalf of the Secretary, and the representative may provide written or oral comments to the Secretary concerning the certification of any voting systems at breaks during the on-site certification testing or within a reasonable period after completion of the on-site testing. And C, to the extent there are periods during the on-site testing when proprietary information must be discussed among the vendor, the contracted testing examiners, and the Department of State, plaintiff's representative will be excused from the testing room. Number 3, robust pre-certification auditing. Number 5, the Secretary will direct each county to audit all unofficial election results using robust pre-certification audit methods to be determined based on the recommendation of a work group established by the Secretary consistent with applicable statutory authority and the following principles. A, pre-certification audits must be completed before the election results are certified. B, automatic audits must happen automatically without a request from voters or candidates. C, best practices audits shall be conducted consistent with best practices in the field. De-escalation if the initial audit fails to rule out a possible outcome-altering error. With the requisite level of confidence, additional measures must be undertaken to ensure that there are no outcome-altering errors in the vote. 6, the work group shall be formed by January 1st, 2019 and shall complete its written report by January 1st, 2020. 7, plaintiffs shall have the right to designate up to 10% of the members of the work group and at a minimum 1 person. The Secretary shall direct that pilot auditing occur in 2021 and that auditing be fully implemented by the 2022 general election. Attorney's fees. Defendants will pay to plaintiffs $150,000 in a reasonable attorney's fees and costs incurred in litigating this action through the execution of the agreement. Said payment is a complete settlement of all fees and costs and encompasses all fees and costs related to plaintiffs and their agents' participation in the process of certification of voting machines as delineated in this agreement, as well as plaintiffs and their agents' participation in the work group delineated in this. Said payment will be paid by means of one check made payable to the law firm of Emery, Sellery, Brinkerhoff, and O'Brady, LLP as attorney. Defendants will submit the appropriate paperwork for issuance of the check to the Pennsylvania Bureau of Risk Insurance Management no later than 30 days after full execution of this agreement. Enforcement. The parties agree that this agreement between the parties must be considered a private settlement agreement, does not require court approval, and that the parties are not seeking court approval. The parties agree that this agreement may not be construed by either party as a consent decree, nor shall any party argue before any court of competent jurisdiction, federal or state, that this agreement is a consent decree. 12, should any court determine during the term of the private settlement agreement that this agreement is a consent decree, that the private agreement is voided and the parties agree that a petition to reopen the case may be filed. 13, the court shall retain jurisdiction to enforce the terms of this private settlement agreement. The parties agree to request the court to enter an order dismissing the case but retaining jurisdiction solely to enforce the terms of this private settlement agreement. 14, prior to seeking specific performance from the court, if plaintiffs have a reasonable basis to believe that defendants are in non-compliance with the material term of this agreement, plaintiffs will notify the defendants in writing of the specific compliance issues. This notice shall identify with peculiarity the basis of the claim that the defendants are not in compliance in the specific provisions of this agreement that are implicated. Within 30 days of receipt of the notification, the defendants will provide a good faith written response to the plaintiff's notification with a full factual explanation. A, as to why the defendants believe they are in compliance with the agreement, or B, a possible non-compliance in a statement of the defendant's plan to ensure full compliance. Notice, all notices required under this agreement will be sent via electronic mail or overnight courier to the following people: Department of State, care of Timothy E. Gates, Office of Chief Counsel, Harrisburg, Pennsylvania. Emery, Sellery, Brinkerhoff, Beatty, New York, 120. Release and discharge. In consideration of the terms and conditions called for herein, the plaintiffs release and completely and forever discharge the defendants, the Department of State, the Secretary of the Commonwealth, and the Commonwealth of Pennsylvania, their agents, attorneys, servants, representatives, and employees, past and present, and their past, present, and future agents, attorneys, servants, representatives, and employees, and all other persons with whom any of the former have been or now or may herein be affiliated of and from any and all past or present claims, demands, obligations, actions, causes of action, rights, damages, costs, expenses, and any claims for compensation or punitive or other damages of any type which relates to the subject matter of this civil action. This release shall not prevent plaintiffs from seeking court enforcement of the agreement. Plaintiffs expressly waive any and all claims which relate to the subject matter of this civil action, but of which the plaintiffs do not know or suspect to exist, whether through ignorance, oversight, error, negligence, or otherwise, and which, if known, would materially affect the plaintiff's decision to execute this agreement. All parties acknowledge that they have had the opportunity to consult with counsel and further acknowledge that they fully understand and agree to the terms of this agreement. No admission. It is understood and agreed that this settlement is a compromise of highly disputed claims entered into to avoid further litigation. Nothing contained herein shall constitute or be construed to constitute an admission by any part of the merits of claims or defense which were or which might have been asserted by an opposing party in the course of litigating the captioned action, nor shall anything contained herein constitute or be construed to constitute a concession by any party that it would not have prevailed on claims or defenses which were or which might have been asserted by it in the course of litigating the captioned action. The settlement has no precedental value and may not be cited or relied upon by any person in any proceeding for any purpose. It is not to be construed as an admission of liability on the part of any party being released here under any such liability being privately or being expressly denied. Miscellaneous provisions. Plaintiffs represent and warrant that besides themselves no other person or entity has any interest in the claims referred to in this agreement except as otherwise set forth herein, that they have the sole right and exclusive authority to execute this agreement. This agreement contains the entire agreement between the parties with regard to the matter set forth herein and supersedes any and all prior agreements between the parties relating to all or part of the subject matter of this agreement, and shall be binding upon and inure to the benefit of the successors and assigns of each from the effective date of this agreement until December 31st, 2022, the expiration date. This agreement shall be construed and interpreted according to the law of the Commonwealth of Pennsylvania. If, subsequent to the effective date of this agreement, any provision or term of this agreement is held to be invalid, illegal, unenforceable, or in conflict with the law in any jurisdiction, the validity and legality of the remaining provisions will not be affected or impaired thereby. Any headings or subheadings used herein are for reference purposes only and do not affect the substantive provisions of the agreement. This agreement may be executed in counterparts, and a facsimile or .pdf signature shall be deemed to be and have the same force and effect as an original signature. Stipulation of dismissal. The parties agree that they will sign and submit a stipulation of dismissal with prejudice pursuant to Fed R. Civ P41.A.1.A.II to the court at the expiration of this agreement. Timothy Gates is going to sign his signature, Chief Counsel. Any headings or subheadings are for agreement stipulation. Okay, so another one, Sue Unger, she signed for the defendant. And then the Ilan M. Mazel and John G. Papananu, I don't know, Papa something. So, yeah, there's 4 signatures that's on it, and that's the Pennsylvania settlement. And I know they said that I'm not allowed to speak about it, right? We're not allowed to use it as, precedent. This is something totally separate, but it's actually kind of genius. So, instead of awarding Jill Stein a bunch of money because Pennsylvania has a shitty voting system, Jill Stein sacrificed the private gains that she could have made on this by making sure that the whole state of Pennsylvania gets better election systems. So Jill Stein's lawsuit, the recount and the subsequent lawsuit, has made Pennsylvania a better democracy. So by 2020, so by next year, Pennsylvania is going to have all written ballots, and then by 2022, they're going to have periodic audits. Why are they going to have written ballots? Why are they going to have periodic audits? Because Jill Stein recounted the goddamn vote and then she followed it up with a lawsuit. So recounts should be a part of American politics. They're expensive, and maybe I guess that's a good get a GoFundMe or just pull a Jill Stein, get a bunch of people to donate to your recount efforts. So, yeah, people say, well, what did Jill Stein do, right? It was irrelevant. She didn't get anything done. She did do. The Pennsylvania settlement is a fucking major deal. And it's better. I think it's better because instead of, they recounted a few of them, and then they had like a partial recount on one, and then they found out there was 100 more for Hillary, I want to say, in Michigan or Wisconsin, and then 100 more for Trump in the other states. So the recount didn't change anything, except for it showed that the election, there was some election integrity, at least for the things that, Jill Stein had pointed out and tried to sue for. The 75,000 blank ballots. There were 75,000 blank ballots, so, that's apparently not 75,000 and only changed 100 votes, so I'm not for sure. So, yeah, there's a major success, just like when Ralph Nader got 3% of the national vote in 2000. Maryland and Delaware have a Green Party today. They got a Green Party today because Ralph Nader ran, in 2000. So the Green Party of Delaware and Maryland owe their existence to Ralph Nader. So those are successes. Before in the 90s, these independents could only get on like 10 state ballots. Now they're getting on all 50. So they're, essentially tackling this major problem of ballot access with a vengeance. And, yeah, good for them. So, fantastic. There is a reason for Jill Stein's recount. $7 million. For some reason, it cost $3.5 million to go, for the lawyers in Wisconsin, and they didn't get shit done. Meanwhile, these lawyers here for the Pennsylvania settlement were successful. And so this is fantastic. This is amazing. Pennsylvania is a better state today. They have a better democracy today because of Jill Stein. So you want to sit there and shit on Jill Stein? She made our democracy better. She also changed the game in terms of everything she was speaking about. Every word out of her goddamn mouth was fucking right and revolutionary and progressive. Every fucking word out of her goddamn mouth about every single topic, every single issue, every single topic, she was 100% right about. And then she changed the game when it comes to the recount. So her narrative, her enthusiasm, and then Jill Stein's recount is going to be in history, in the history books forever and ever. And that's good. That's a better precedent than Bush v. Gore. Bush v. Gore, Supreme Court can, stop recounts if they don't think it's a fair well, it doesn't look like it's going to be fair to us, so we're going to stop it. Well, should we do another recount? Should we do one that's fair? No. No, just stop recounting and we'll just, give this fraudulent election to the person that they had already declared a victor. A month ago, Kathleen Harris? She's the Secretary of State. She's Bush's family, friends. She campaigned with the Bushes. We're going to go with her verdict? Fucking Bush v. Gore. What, equal protection clause? What's the equal protection clause? That when we do a recount, everybody must, have somebody look at the recount and say, yes, that is correct. And it must be, that standard must be set all across all the counties of Florida. I thought equal protection was just that every citizen had a right to, protection under the law. So there was the 14th Amendment, that's the Civil War Amendment, right? So that's saying that black people, you're going to defend the rights of black people too in addition to everybody else. So therefore, that's equal protection, to make sure the states aren't depriving the citizens of individual rights. So what the fuck could they say equal protection was with the recount? Some convoluted fucking thinking, that's for goddamn sure. But it's a precedent, so you have to, in American jurisprudence, Bush v. Gore means something. It means you can't do the recount. You have to look at their goddamn objections and do whatever do the recount consistent with the parameters that were set up in Bush v. Gore, which is fucking bullshit because Bush v. Gore was wrong. It was an incorrect opinion, and, Al Gore is to blame, but anyways, Jill Stein, precious revolutionary, champion of the people, forever and ever.